So the needless to say, this sort of overarching merger of all these companies did not work out as planned. Uh, the these folks all went to all became colleagues. Mr. Holm, Ms. Pettit's client, my client, Mr. Nall, as well as Ed Delgado, which is a party in one of these other cases that was recently transferred to your court. Um, but then Mr. Holm gets fired, my client gets fired, uh, and these various disputes arise. When I first filed my answer, these folks initiated a separate lawsuit against my client. When I first filed my answer, I didn't fully understand the interrelated nature of all these cases, but subsequently, my adversaries in my case have joined Ms. Pettit's clients, Mr. Holm, and his company as responsible third parties in my case. They've served a very robust subpoena uh, on Mr. Holm in my case. By the way, another party that the East Coast financial backer of this whole thing is Southfield. That's a Connecticut-based private equity firm. I know that Southfield has been joined as a party in Ms. Pettit's case. I have not joined them as a party yet in my case. I have served a subpoena on them. Um, it all ties back to this overarching acquisition and what 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 my adversaries in my case are now saying, their excuse for my claims against them is, well, we didn't defraud you. It's that we were defrauded by Mr. Holm. So if there was any misrepresentation made, it was made by when we first purchased Mr. Holm's company. And so then when we made these representations about rolling your company up into this overarching company, any inaccurate information was simply passed along um, from Mr. Holm, and so it all became part of the same company. I mean, that's kind of the factual background.
So let me ask a question, because all these companies have similar names, and I should know this, I guess, but I'm not sure. Five Star Global LLC, is that the same company that we're considering putting into receivership, or is that a different entity?
That is exactly the entity that we're considering putting into a receivership, and that is the company that sued my client in the 160th, and that's the company that is litigating in your honor's court. I believe that company, Five Star Global LLC, is a party in all four of the cases. There was a motion to transfer these other two matters that I did watch on YouTube a week or so ago, and Five Star Global is kind of the overarching party in all four of those cases, and it's the company that we're considering putting into a receivership. My client is a part owner of that company. Ms. Pettit's client is a part owner of that company, and just as a quick housekeeping matter, Your Honor, at the hearing on the motion to transfer, I believe the court was keen on consolidation of the four cases, which I very much support. I filed a motion to consolidate, which I set today as well. However, we inadvertently only served the notice of hearing in my cause, and so Southfield and Mr. Delgado have objected to having the motion to consolidate heard today. So hopefully we can hear that as soon as possible. I would hope that these cases can be consolidated certainly before the receivership hearing.
So potentially, I just want to make sure I kind of understand how everyone fits together. Potentially, the receiver would be in charge of this. Any claims against your client could potentially be an asset of the receivership. Is that correct?
Yes.
Okay. All right. Response?
Thank you, Your Honor. I'd like to start by talking about what are the primary and key differences between this mid-market case and the Holm case that is pending in your court. So
Okay.
these cases arise out of two completely separate transactions that have no relationship between the two of them. So the first transaction was an asset purchase agreement where my client, Five Star Global, purchased some interests from Mr. Holm, which is Ms. Pettit's client. That was executed in May of 2018. And the case that Ms. Pettit has brought and named my client as a defendant involves, among other things, some allegations that there was fraud in connection with that agreement, that an employment agreement with Mr. Holm was not honored, and that he was wrongfully terminated, as well as some issues relating to a
And
loan.
that's all in the other case, correct?
That is in the Holm case.
Okay.
And also related to a loan that Mr. Holm allegedly made to my clients. So those,
Okay.
put those in one bucket, because none of those claims and none of those transactional documents are at issue in the mid-market case that Mr. Reamer's client is involved in. That case involves a subsequent asset purchase agreement where my client decided, we purchased one thing, put that aside, we're going to go on and purchase another asset, but these are different assets, different parties, and different transactional documents. That relates to the mid-market case in which Mr. Reamer is involved. It relates to an asset purchase agreement that was signed about 7 months later or 8 months later in January of 2019, and then also involves some employment claims for Mr. Holm related to an employment, I'm sorry, too many different parties here. Some employment claims related to Mr. Null, and that has nothing to do with Mr. Holm. So Mr. Holm is an employee, was an employee of 5-Star. Mr. Null was an employee of 5-Star. They have two separate and unrelated employment agreements. They both happen to be fighting about those employment agreements with the same entity, but the two don't overlap in any way. And so the notion that there is some efficiency gain by transferring the cases, I think, has no merit. And the court is, I know, very well familiar with the In re Capel case that sets the standards for transfer, and that requires that a comparison of the claims at issue and the conduct at issue, not just saying, well, the party's the same, so transfer is proper. And in that case, it involved a single piece of property, and the court said, well, just the fact that there's a single piece of property and just the fact that both cases involve injunctive relief related to that property is not enough in itself for transfer. And I think there's an analogy to be made here. Just because the same company is involved, and even though that company may or may not be in receivership, I don't think that's enough to justify a transfer. I mean, certainly if the claim.
So let me ask you this, just from a logistics standpoint, if there, and again, I haven't decided on the receivership. I did want to have someone in place just in case, but if there is a receivership, wouldn't the receiver be in charge? Ultimately, this would be an asset of the receivership, right?
I think that's probably the case. I haven't run down sort of where that line is, but I think that may be the case. But I don't know that prevents that receiver from litigating that claim in the 160th, just as a receiver could maybe go into a different jurisdiction and file a case in a different court if necessary, or into federal court and file a case if necessary. The mere fact that the receiver is appointed by the 68th, I don't know necessarily means that the receiver can only litigate in the 68th.
No, I agree with you on that. That's a good point.
And then the last piece I want to raise is, the timing of how this motion was filed, I think highlights that it has an element of gamesmanship to it, in that there was no local rule disclosure of related case when the case was filed. And this motion to transfer came a couple of days after Judge Redmond entered some relief against Mr. Reamer's client. In particular, struck the jury demand in that case under a waiver of a jury trial right in the transactional documents. And so it feels, because that motion to transfer was also accompanied by a motion to consolidate, it feels like that is an attempt to end run around the jury waiver and essentially get a jury trial by combining with the Holm case, which does have a jury trial right. And so because of that, I think that provides an additional basis for denying the relief that's requested.
For the consolidation, at least.
Certainly for the consolidation. And I think, again, because of the In re Capel factors and the failure to make any sort of disclosure of a related case and not seeking any relief until, being dissatisfied with some rulings from the 160th, counsels against transfer as well.
I mean, I think the fundamental issues just are the cases related. Everything else is, it does put it in a different light, but the real standard is, are they related? So he's saying that these cases, Mr. Bexley is saying that these cases are not related because they involve different parties, different transactions. and he's relying on the Capel case. What's your response to that?
Yeah, not the case, Your Honor, at all. Certainly, the cases are not identical. There are nuances, of course, but absolutely, these cases are related. And the way that Mr. Bexley characterizes this transaction as being two completely separate things is just flat out wrong. I mean, it was two deals. They purchased Mr. Holmes' company, and then they added my client essentially as a subsidiary, rolled our company up into that company, and then the whole thing uh, blew up all at once, and all these folks started suing each other. The dispute with Mr. Holmes started before my dispute, and they sued my client in a separate action. But absolutely, it's all related, and it's interesting that Mr. Bexley would bring up that adverse ruling, uh, because absolutely that was part of the timing, because they were arguing the same things that they're arguing in the cases in this court, in that separate action in the 160th. They're saying, well, we were defrauded by Mr. Holm, uh, and so if there's anything that we owe to you, Mr. Nall, it was Mr. Holmes' fault. Those are exactly the same issues that are pending in this court, Your Honor. And so the timing absolutely had something to do with it. As far as the jury demand goes, I mean, there were waivers in our contracts, and that's fine. I mean, my understanding is that the cases in your court are going to be tried to the court, and that's perfectly fine with us. And I don't. I mean, as far
I want to make clear that 100% clear on this is that even if I do transfer and consolidate this, I am not going to reverse Judge Redmond's decisions that she's made so far. So if it's an effort, if you really feel like this, if this is an effort, I don't think it is, but if this is an effort to try to transfer it to this court to try to get me to reverse Judge Redmond's rulings, I would be very, very unlikely to do that. Does
Absolutely
that change your position on this? Do you want to maybe not file the transfer or the consolidation?
Absolutely, Your Honor. I will go on the record right now as saying that we will do absolutely nothing to change either of those rulings, which we fully respect. That has absolutely nothing to do with any of this. And
Ms. Pettit, I see that you're here. Are you a party to this case as well, or are you just here observing for the other case?
Your Honor, I'm here observing for the other case. I don't have a dog in the fight between Mr. Reimer's client and Mr. Bexley's client. The only thing I would add that I think has not been mentioned is the fact that my client's company was certainly acquired by Mr. Bexley's client prior to the time in which Mr. Reimer's client was acquired by the same company. But when that second transaction was going to happen with Mr. Reimer's client, Mr. Bexley's client didn't have the money to finance it. So my client, Mr. Holm, and his companies financed the acquisition of Mr. Reimer's client. So to say that that's not somehow related is a little bit interesting to me. But again, I don't have a dog in this fight. I did indicate I'm unopposed to this motion, but my client funded that purchase.
Well, I guess what concerns me about this is that, so there's, in your case, Ms. Pettit, there's not a jury trial waiver. And then in this case,
that's
there
a good
is a
question, Your Honor. It is, and I haven't looked into all of the specifics of that jury waiver, but it is my belief that there is a jury waiver and the documents between my client and Mr. Bexley's client. Mr. Bexley can certainly correct me if I'm wrong, but that was my understanding, is that there is a jury waiver. If I'm wrong, Mr. Bexley can correct me, but I don't think we get a right to a jury.
I'm going to need to look back at the documents. My recollection is that some of the claims are subject to a jury waiver. There's several contracts at issue in Ms. Pettit's client's case, and so we had not yet explored the jury waiver because it's more complex in that case, and some claims might be subject to it, some might not, whereas it was pretty clear that all of the claims in the mid-market case were subject to a jury waiver. And there is a jury demand, at least at this point, is my recollection in the Holm case.
I mean, it does really seem like these things are related. I'm a little concerned about consolidating it because of this jury trial issue. the jury trial waiver issue. I guess, I mean, there's two ways we could do this. I could transfer it and then consolidate it, and then if there was some issue about some cases needing a jury and some claims needing a jury and some not, we might want to separate those claims out at the ones that are entitled to a jury. But it doesn't seem like anyone really knows if that's the case or not.
Yeah, it sounds like, Your Honor, to the extent that there's some claims that would require a jury and some that would not. I think that will be the case. If what Mr. Bexley says is accurate, it sounds like that will be the case even if Mr. Reimer isn't a part of that case. Because I do strongly recall that there being a jury waiver that is going to apply, I assume, to all claims, but again, I haven't drilled that down. But it sounds like that's going to exist regardless, if that's indeed the case.
Has Judge Redmond already signed the orders on the that we were talking about?
Yes, Your Honor, and they're actually attached to our response.
Okay, I wasn't sure if she had signed those yet. Well, Mr. Bexley, I want to be fair here. It sounds like the motion to consolidate wasn't officially set for today. Do you want me, I'm going to grant the motion to transfer. Do you want to hold off on me ruling on the consolidation until you guys can look at this jury trial issue and it can be officially set, or do you want to just go ahead and do everything all at once?
So I've responded to the motion to consolidate, and I got notice of it. The issue, as I understand it, is that there are some parties to other cases that are also subject to a request for consolidation who did not receive notice, and so they're not here today to make their position on the record.
On this case?
Not on this case, but the motion it was a single motion involving a total of 4 cases, although one of them is inactive. So basically 3 active cases. So that.
Wait, am I just? I thought I was just transferring this case. I'm not transferring.
Yes, I'm sorry. So you have already transferred the other case that is subject to the motion to consolidate. So the transfer motion applies only to this case. The consolidation would add an additional case.
Yeah, I think I want to hold off on the consolidation then.
Yeah, I think that's right, Your Honor. And so if we transfer it today, then I can follow up with all the parties, and I've tried to confer on the consolidation. I've gotten an opposition from Mr. Bexley, but Southfield and Mr. Delgado have, I think, indicated that they're opposed. They haven't really explained why. So it might be helpful leading up to the status conference next week to have a discussion about this with all the parties.
So I'd like, I guess we don't have to do it this way, but it would be efficient, and I'm trying to think this through, but if somebody could contact Mr. Buchanan and let him know all the different cause numbers on this so he can look at it, because I don't want to be in a situation where, because there's so many different entities that in lawsuits and everything, that I appoint Mr. Buchanan and then he has a conflict because in case number 4, he, I don't know what his conflict would be. He has a conflict, but he doesn't have a conflict in cases 1 through 3. If somebody could go ahead, maybe Ms. Pettit, or
I can do that, Your Honor.
Why don't you contact Mr. Buchanan? And again, I haven't made a decision on this, but I don't want to appoint him if there's going to be a potential conflict. And I don't know that there is going to be. I just don't know anything about the other cases. So just make sure that he knows about that before next week.
Yes, Your Honor.
And I guess, are all 4 of these cases involving 5 Star Global LLC?
Yes.
One of them does not. I mean, one of them mentions 5 Star Global, but we are not a party to one of them.
Is that case in my court or in someone else's court?
That's in
your court.
Oh, okay. So I'm kind of getting all of these right now. All right. Okay. Well, we'll figure this out. Go ahead and email an order of transfer, take out the consolidation, just that I'm not ruling on that yet. Go ahead and email that to my court coordinator and e-file it as well.
Yes, Your Honor.
Mr. Reimer. Anything else today?
Must.
That's it for now, Your Honor.
All right, guys, you guys be safe.
Thanks,
Thank
you too.
Thank you,
Bye-bye.
Joseph. Have a nice day.
You too. Okay. All right. Anyone else here for any other cases? Mr. Woolley?
Yes, I'm here for the Jellensberger motion for continuance.
All right, so the next one looks like it is, oh no, did the special exceptions get canceled? All right, so you're on the Jellensberger, is that right?
Correct.
Okay, that looks like a new one. Is this set on the jury docket?
Yes, Your Honor.
October 6th, okay. Is your opposing counsel here?
I
I'm
don't
here.
see her. Kristen?
Yeah, I'm here. Can you hear
Okay.
me?
And what is your name, ma'am?
Good morning, Your Honor. Kristen Perry. I'm here on behalf of State Farm.
Okay. So kind of tell me what's going on here.
Do you want to go ahead, Kristen, or?
Go for it. I can't get my screen to work here.
Okay. On this one, we filed a joint motion for continuance. We're originally set for October 13th. And currently, I mean, there's many reasons why we filed it. We have a little bit of discovery still left to do. Also, we weren't sure of when jury trials were going to get reset. I think the last thing we heard is that they may go forward starting October 1st throughout the state, but I just wanted to be sure about Dallas County and when.
There's a new order that just came out, and it's not a model of clarity. The way I interpret the order, and it's not all judges, I think, interpret it this way, but it's how I've interpreted it, is that it delays trials until December 1st unless certain factors are present, including that the county has a jury trial plan, which we don't have one yet. We're in the process of creating one. There's no way that we're going to have a jury trial plan in this case could be ready to go by October, whatever date this is. The earliest I'm even looking at possibly trying cases would be November 10th, and that's kind of up in the air with this new order. So I'd suggest we just reset it to next year sometime.
Okay, I think in our joint motion, we just had 180 days out. So that would be approximately April, mid-April, maybe early May.
Okay,
Either one of those is fine with me, Your Honor.
let's see. So what date exactly did you want?
Either May or, I mean, is it going to be the same kind of trial docket as it has been previously? I think earlier I had a motion for joint motion for continuance in your court, and we had talked about maybe having a 6-person jury instead of 12.
That would be incredibly helpful if you guys would agree to that.
This is Kristen, Your Honor. I need to check with my client, but I think that they would probably be agreeable to that in this case.
Okay. So you wanted March, you said. So this is the 16th, 23rd, 30th, April 6th, or April 13th.
We can do it April 13th. Is that all right with you, Kristen?
Sure, that works.
Okay. All right. April 13th. Ronnie, go ahead and reset it. I'll go ahead and sign the continuance now. Have you already been to mediation on this?
Not at this point. We're discussing options to try to alleviate that too, and possible arbitration. But
You said arbitration?
Possibly. We're just trying to figure out new ways to handle cases now, because we're sure that all the court dockets are going to be pretty booked on every case.
One thing that I've thought about doing is ordering parties to non-binding arbitration. I can't order you to binding arbitration unless you have an arbitration agreement, but I can order you to non-binding arbitration. Judge Ginsburg, I probably ordered you either probably give you a choice of 3 former judges, Ginsburg, Pfeiffer, or Jordan. And then you guys could each strike one if you wanted to do it that way. But why don't you talk about it? That might be another way to do it. If you guys want to agree to binding arbitration, we could also do that and maybe pick those 3 judges and strike one each, or I'm open to suggestions, but I agree we need to figure out something to do here. I will say that the most recent proposal that's kind of on the table is that we, during the period of the pandemic, that we would do jury selection online, so via Zoom, and then the remainder of the trial would be in person. I don't know if that's going to be what happens, but that's the kind of most current thinking on the issue. Nothing's decided. So just FYI, that's another thing that may be coming down the pike. I'm going to be pushing very, very hard that if by January 1st we don't have an end to this pandemic, that we start doing at least portions of the trial in Zoom and start trying cases in January. But we have to have a jury plan in place. Does that help at all, guys?
A little bit. Yeah, I think so. A little more guidance on what to expect going forward.
Possibly, yeah. All right. Anything else, guys? All right. Just let us know as soon as you can, and we're open to suggestions.
All right.
Thank you.
Thank you.
Thank you, guys. Anyone here on any other cases?
Yes, Your Honor.
Yes, Your Honor.
What are you here on?
The Harvey case, Your Honor.
Okay. Okay. Harvey is right here, correct? Motion for leave.
Correct, Your Honor.
Okay. Do y'all want a record on this?
I will say yes, Your Honor.
Sounds good. I'm fine.
Let's go on the record on cause number DC 1900466. Misty Harvey versus Performance Food Group, Inc. Counsel, make your appearance.
Your Honor, Andrew Cooper on behalf of defendant Performance Food Group Incorporated, excuse me.
Good morning, Your Honor. This is Lamar DeLong on behalf of plaintiffs Misty Harvey and Ronald Schillinger.
All right, let's go and proceed.
Yes, Your Honor. This is defendant Performance Food Group's motion to designate a responsible third party, in particular, Mr. Adam Johnson. Your Honor, the reason we've designated Mr. Johnson as a responsible third party, and Your Honor has already heard a motion for summary judgment on Mr. Johnson's involvement in this case. This is a motor vehicle accident case. It's clear from the video evidence that a Volkswagen vehicle driven by Mr. Johnson had been stopped and/or was moving at an exceedingly slow rate of speed in the middle of I-35E at night in the rain right before this accident occurred. And we have raised the responsibility of Mr. Johnson for the operation of that vehicle and asked that he be designated as a responsible third party. The plaintiffs have come up with some arguments in response, Your Honor, but the fact of the matter is that we have properly pled Mr. Johnson's involvement in this accident. We have given them fair notice of the fact that we do intend to raise his involvement in this accident and make him a responsible.
You say that I've already ruled on a summary judgment in this. What? Tell me about that. Your
Honor, they filed a no evidence motion for partial summary judgment with respect to, among other things, our assertion of the fault of third parties defense. And in particular, with respect to Mr. Johnson, and if Your Honor will recall, this was a few weeks back, there's video evidence of the crash, and it clearly shows Mr. Johnson's vehicle stopped in the middle of the highway right before this accident occurs. That in and of itself, we are going to contend is negligent operation of Mr. Johnson's vehicle that caused this accident to occur. Your Honor denied plaintiff's no evidence motion for summary judgment on that affirmative defense because there was a genuine issue of material fact, and we have filed a proposed order denying that motion. Or we are about to file it. If it's not on file, it will be shortly. But nevertheless, even after that particular ruling, they are continuing to challenge our designation of Mr. Johnson as a responsible third party. And to focus on the standard applicable under the Civil Practice and Remedies Code, Your Honor, we have properly pled Mr. Johnson's involvement in this.
I'm familiar with the standard, so let me hear the response.
Yes, sir. Good morning, Your Honor. Built into the rules on responsible third party is an inherent gatekeeping function charging the courts with weeding out this very kind of pleading. You will see in the defendant's designation that they allege zero facts to support their theories of liability against Mr. Johnson. Instead, they make conclusory statements that he failed to keep a proper lookout and that he failed to operate his vehicle as a reasonably prudent operator. In fact, I will share my screen with you so you can see their designation. Give me 1 second.
Give me a second. Go ahead.
Is that coming up on your end, Your Honor?
Yes.
Well, as you can see in paragraph 6 of their designation, this is the only section where they attempt to describe the actions of Mr. Johnson and say that he is a responsible third party. They say that he caused or contributed to the harm for which the recovery of damages is sought through his negligent acts or omissions when he failed to maintain a proper lookout or operate his vehicle as a reasonable, prudent operator of a motor vehicle would. Furthermore, Mr. Johnson was cited by the Dallas Police Department for his involvement in the accident. They allege zero facts to support these conclusory statements, Your Honor. Without any facts, these conclusory statements do not pass muster even under the most liberal pleading standard. Plaintiffs would be staring down a motion to dismiss had they pled in the same manner that defendant has. They say nothing about the fact that they think that he was traveling at a negligible speed or that he was stopped in the middle of the roadway. They just say that he failed to keep a proper lookout. So I'm not sure how that's even relevant here because he was clearly struck from behind by defendant PFG's 18-wheeler. And they just say that he failed to operate his vehicle as a reasonable, prudent operator without saying anything to support that conclusory statement. The only fact that they allege
it does seem that's pretty sparse.
I agree, Your Honor. And the only other fact that they allege is that he received a citation for his involvement in the wreck. But this is so misleading. The citation that he received was for driving while his license was invalid. That does not show a causal link whatsoever. They have otherwise failed to show anything that Adam Johnson did or didn't do that caused or contributed to the wreck. They claim that he failed to keep a proper lookout. No facts to support that allegation. Your Honor, if this pleading makes it through the responsible third party gauntlet, then the statute is truly rendered meaningless, in my opinion. And if this statute has any teeth remaining, then this court should at a minimum require PFG to replead.
I respond, Your Honor?
Yeah.
So one of the things they contend, Your Honor, is that to get into their specific objections in their motion, they're upset that all the elements of a negligence claim weren't pleaded. And they cite the El Chico versus Poole case for that. But if you look at the elements in that very specific authority that they cite, it's basically causation of the damages alleged in the case and breaches of duty on the part of the person that you're suing. And all of those things, if we could go back to the paragraph that counsel just cited, are specifically alleged in this motion. There are at least 2 breaches of duty that are alleged. There is causation of the plaintiff's harm that is alleged. Those are the very specific elements in the El Chico case that they have cited as somehow standing for the proposition that our pleading was
What are the two?
inadequate.
So I guess you said failure to keep a proper lookout, and what's the other one that you alleged?
Just one moment, Your Honor.
And I can let you can share screen it if you want.
It's failing to operate his vehicle as a reasonable,
Failing
prudent.
to operate the motor vehicle as a reasonably prudent operator would, Your Honor. So the authority that they cite actually supports our pleading, not their objections in this case. They contended that, the fact that all we said was that Mr. Johnson was cited in the accident, and that, oh, by the way, the only thing he was cited for was not having a valid driver's license. And it's clear, first of all, Your Honor, that they do in fact have noticed that Mr. Johnson was cited, and specifically what he was cited for, not having a valid driver's license. It is somewhat rich in this case to hear the plaintiff take the position that Mr. Johnson's lack of a license had absolutely nothing to do with causing this accident, when the entire focus of their case has been that another defendant, Mr. Page, is responsible for this accident, and that PFG is responsible for his actions because Mr. Page should have been disqualified as a driver, not under licensure terms with the state, but under the terms of PFG's own driving policies. Okay, so
let me just say this. I guess my main issue here is just the pleadings are so sparse. I'm not saying that you wouldn't eventually get there and that there's not a basis, but what you said at the beginning and what's in the petition that's been shown to me are not the same thing. And so I'm going to give you 7 days to replead. And then if at that point you still want to bring your motion to designate, then go ahead and get it reset and I'll take a look at it. But Mr. DeLong, go ahead and get me an order ordering him to replead within 7 days. And then if it's still not sufficient, then go ahead and we can have this reheard. But it's just that the pleadings are just not, I mean, if a plaintiff's attorney filed what you filed or whoever filed that, I agree that would probably be subject to a special exception and there would need to be a repleading. And I just, that's the issue here. It just needs to be more specific.
thank you, Your Honor. We will replead.
Okay, go ahead and get me an order on that, Mr. DeLong.
Thank you, Your Honor.
Email that in, email it to my court coordinator, Rhonda Pinson, who's here on the call, and then e-file it as well, the order.
Okay, will do.
And try to get that in today if possible.
Yes, Your Honor.
Right. Thank you, guys.
Thank you. Have a good morning, Your Honor.
Okay. Oh, you can go. Let's see. Where is Ashley? Does she have class? Is she usually here on Mondays?
He was on here a couple minutes ago.
Let's see.
You're still on YouTube.
Oh, oops. Okay, let me turn that off.